Good evening, everyone. The January 21st, 2026 Arlington County Board of Zoning Appeals is now in session. My name is Richard Kaplan, and I am chair of the board. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Into Malice, Judy Freshman, Carol McCoskry, and Alex Kumana. Also present is the professional staff, including Lindsay Klein, BZA coordinator, Brett Goldberg, BZA associate planner, and Stephen Rissy, zoning PRIMS supervisor. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and the procedures for tonight's hearing. This board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modification will promote compatibility of the development with the surrounding neighborhood because the structure's overall size, footprint, and placement are similar to those of the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of the use permit. This board does not have the authority to grant use permits to modify requirements for expanded housing option developments. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property and that the need for the variance would not be shared generally by other properties and such variance is not contrary to the purposes of the ordinance, or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to the adjacent property and nearby properties in the proximity of the geographic area. That the condition of or situation of the property concerned is not of so general or reoccurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance. That granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Lastly, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by other administrative officers in the administration or enforcement of the zoning article, Title 15.2, Article 7 of the Code of Virginia. Now on to tonight's hybrid hearing. For those who are participating in the room, in the front of the table, you will find a QR code linking to a copy of the application packages, including the staff report for each of the cases before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the application packages. If you have not yet seen that report for your case, You should review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. Speakers must fill out a speaker slip online or is also available on the table in the front of the room. After we hear from speakers for or against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers or applicants, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, the board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representatives of organizations, and 2 minutes for other individuals. After the board has gathered all information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority of the membership of this board is needed to approve any motion. Please be respectful of the time allotted. This is a public forum and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Information Act requirements. The Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. I don't believe we have any administrative matters to attend to this evening, so I think we're ready for our first case, Ms. Klein.
Thank you, Chair Kaplan. Case number V-12059-25-UP-1, carryover and revised. A use permit request carried over from the July 16, 2025 and October 15, 2025 BZA hearings by Brush Arbor Home Construction LLC, the applicant, on behalf of Curtis and Samantha O'Frory, the owners, to permit right side setbacks at 5.6 feet to the building wall and chimney, 4.6 feet to the building eaves, and 1.9 feet to the window wells, instead of 10 feet to the building wall, 8.5 feet to the chimney, 6 feet to the building eaves and window wells as required, and to permit left side setbacks of 9 feet to the building wall, 5 feet to the stoop, and 5.7 feet to the areaway, instead of 10 feet to the building wall, 6 feet to the stoop and areaway as required, and to permit a total aggregate side yard width of 14.6 feet instead of 18 feet as required regarding a new one-family detached dwelling in the R6 zoning district on the premises known as 3174 20th Street North, Lyon Village. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised. Note there is supplemental material for this case that came in after the application packet was assembled and printed. And please also note that we have additional speakers who have signed up to speak on this item.
Thank you, Ms. Klein. Do my colleagues have questions for staff? Ms. McCoskey.
So this says it's a carryover and revised, but is it revised in fact, or is it the same application, but it was asked to be deferred last time?
It is the same application that was seen in October. It was revised from the July version. So no changes since
Okay.
it was seen in October.
Okay, thank you.
Are there any other questions for staff? Ms. Malice.
I just want to confirm that starting on page 15, there's some documentation that looks like a staff report. Can I just confirm that that's an applicant submission?
That is correct.
Okay, thank you.
Anything further? Is the applicant with us? Would you like to speak to your application?
Good evening. First, thank you. Thank you to the staff. Thank you to the board. We really appreciate it. I think we have a new appreciation for the process. We get a chance to talk to our neighbors. We get a chance to learn more about it. Mr. Reese here, and Stephen, I think he's on there as well. We'll keep our comments pretty brief. Look, our whole goal and our intent here was really just to sort of build a home that we can have our kids and our family in. We now have a new appreciation for minority rights, and majority rule. Change happens, and those things are important. I think it's also important to sort of hear what folks are saying, and then try and take those into account, whether it's one-on-one conversations, whether it's hosting our neighbors and answering those questions, or getting a majority, right? I think 12 plus signatures from the folks who live every day in our neighborhood. The reality is, we hope you have your support. Majority of you would be. If not, we understand there are rules that sort of govern how Arlington is built. That's why people want to live here. That's why we want to live here. But I think more than anything else, we just sort of appreciated. I think originally when we started, we didn't really kind of appreciate the process. Why do we move over another month? But in doing so, gave us more time to engage with staff. I think I probably had more than enough meetings with Stephen and the broader team. Talk to our neighbors as well. So that really is the headline. We understand change happens. My wife and I have lived in and around Arlington for over 20 plus years, and we've seen that change happen, right, from a house to an apartment to a home. And yeah. So I just appreciation not only for the staff, you guys' time. I don't think, again, when we started before, we had an appreciation for it. So that's really it. So you want to say a couple words, and then we'll sort of let the folks answer questions.
Can you make sure the microphone is on?
Oh, can you not hear me? I need to.
I can hear you. I'm not sure everyone can though. Is the button, does the button need to be pushed to turn on the microphone?
Get closer.
There's a light on.
There's a light on. Is this better?
Oh, then that might be okay.
Nope, you're good. On the other side, right here.
That might help a little bit. Feel free to adjust.
Okay.
Okay.
Ours have this red light. That's what I was wondering.
Okay, got it.
Yeah. I just want to say thank you. That this process has been very enlightening. As my husband shared, we've lived in and around Arlington for 20 years, and really excited to continue to grow our family and build our family home here at 3174. So thank you.
Thank you. Do my colleagues have questions for the applicant? Ms. Freshman?
Yes, I have a question. My understanding is that you're removing the house that's there. So
Removing the house
you're
that's-
clearing the site in order to build a new house.
Right.
And typically, a lot of our cases are homes that are existing homes that often were built before the zoning ordinance came in.
Mhm.
And so they need exceptions for changes like that.
Yep.
But when you have an empty lot,
Right.
which you propose,
Mhm.
then is there a reason why you couldn't design a house that would meet your needs that wouldn't require exceptions?
Yeah, no, and look, I think we really thought through that a lot, and I think that what we want to do is build the house to kind of where it was, and quite frankly, just attach the garage, right? Because we have little kids, it gets cold, and we want to bring them in. We understand sort of like the long-term impacts that the 3.7 feet, 3.6, 3.3, I think, could do to it. And so the real thing is we want to attach the garage and sort of like the plan of where it currently was. But believe me, we spent a lot of time about, hey, could we come into because it was wider before. And I think in the conversations I've had with Steve and the broader Arlington staff, can you adjust it? What does our aggregate setback look like? What does the total look like? And we went back. That's why the plan doesn't look like it was before. Really trying to be, how do we minimize that as much as possible? Talking to our neighbors, getting support of everybody else. But I totally hear you. We really spent a lot of time thinking about how to minimize it so that the aggregate setback was only as minimal as possible. And in the reality is the house is actually going to be exactly where it was before. So it's not going to look any different. It's basically taking that new room and having a garage to it. So the visibility will look exact same.
Ms. McCoskey?
Yeah, but it is going to be a much bigger house, right? Because it goes a lot further back, but you're right. But side to side, it's going to be in the same location.
Yeah, side to side, same location. Yeah. And the reality is we can actually go further back, right? In terms of like the total allowable.
Oh, right,
But
okay.
But we still want a backyard for the kids to run
Yeah.
around. And so we sort of limited that sort of this, it's a back and forth.
Yeah.
Yeah. And look, we get it. Believe me, if you asked me about 8 months ago versus today, it's a great appreciation. But yeah, we understand that
Oh.
there's much more. But yeah, the intent,
Side to side.
side to side, it would be the same. Yeah.
Okay.
Why don't we get to the speakers and then we can circle back.
Guys, thank you so much.
Thank
I
you.
really appreciate it. We really do.
Thank you. Is our first speaker with us? I don't want to butcher that name. Marispas. Marispan.
I had problems with this last time. Okay, I think you can hear me. Good evening, board members. My name is Mark Marispan. My wife and I own the lot number 833, which is the immediate right side property to the O'Forey's property. And obviously, we would be the ones who are.
What's the house number?
House, no,
Eight-
We're all looking at maps.
Oh, 3176.
Thank you.
So obviously, we're the ones who are most significantly impacted by these side setback requirements, as well as Ms. Doherty. And we'd like to note at the outset, we have no objection to the O'Forey's right to modify or reconstruct their home. That's a courtesy that all Arlington residents should give to one another. And so we extend that courtesy to them. And we have no issue with that whatsoever. Our complaint, though, is no one has ever explained to us why this new construction should harm our rights. And let me elaborate on that. First of all, as a legal matter, we agree with the staff's conclusion that the permit request does not seem to satisfy the criteria in section 15.6.8. And we were especially struck by the fact that the last time the board permitted a use permit seeking similar setbacks to those requested by the applicants was in 1954. That was 72 years ago. But I'd rather not focus on that, but just our personal angle here, which is we're looking at this house next to us that is very close. We have posted pictures in our letter from October showing how close the properties are. That's a historical artifact that predates all of us. And now we're going to have a property that's dramatically larger, double the footprint, and that will impact our privacy, our ability to enjoy our property value. And what if one day we want to make changes? The other point I want to make is precedent. Precedent is explicitly part of the zoning ordinance because the staff is asked to analyze every new permit against what's in the neighborhood. So if this is granted, what's to stop BCN or anyone else from asking for a use permit simply as a matter of preference? There's no hardship being alleged here. It's just preference. So I'd ask the board to consider what precedent they might be establishing were they to grant this use permit. Thank you very much.
Thank you for your comments.
Thank you.
Mr. Kurtz.
Good evening. Thank you for allowing me to speak today. I'm especially pleased.
Should you identify?
Are you a neighbor?
My name is Adam Kurtz. I am a neighbor across the street at 2005 North Hancock. It would be diagonally across the street and one over on a corner, on the corner. What makes me pleased to be here is one neighbor supporting another neighbor. And nothing's wrong with coming to this meeting or the board and giving your opinion and opposing the county or opposing modifications. But I'm excited and privileged to be here to support my neighbor. I recently moved to the neighborhood a few years ago. Within 2 blocks, there's half a dozen houses that have been torn down and, approved by this board, I assume, and I appreciate the process. This wonderful homeowner and neighbor lives in that house right now. That's unusual. Half a dozen houses that have been torn down, by builders or other people, and then they're sold to new owners. Here we have a neighbor that lives in the community for years, wants to upgrade their home, and I support that. And I would also say that certainly, without measuring to the foot, this new home clearly fits into the scheme of the neighborhood of old homes and new homes, which are larger. And I'm just glad to support my neighbor and also and I want to thank and support the board. Thank you very much.
Thank you for your comments. Ms. Doherty.
Good evening, I'm Sally Ann Doherty, 3170 20th Street North, Lot 753. The left side adjacent neighbor to the applicant's property at Lot 754. Applicant's use permit first heard at the July 16th, 2025 BZA hearing has been deferred twice to allow them to modify their building proposal. However, after 6 months deferral, the January 14th staff report at page 3 shows that the proposed aggregate side setbacks have only been reduced by 7/100ths of a foot, from 14.67 to 14.6 feet, thus continuing to exceed the required maximum 18-foot aggregate side setbacks for R16 single-family homes. In remarks before the board by two immediately adjacent neighbors and in written comments by all 4 adjacent neighbors, we have continued to detail our reasons for opposing applicant's use permit. I presume I also speak for many other Arlington owners of R6 single-family homes in reiterating that for the board to permit applicants to build a new home that exceeds the required maximum 18-foot aggregate side setbacks sets a very concerning precedent. This will allow and indeed will invite builders of R6 single-family homes to similarly exceed the required current maximum side setbacks. Therefore, we urge the board to approve BZA staff's now 3rd proposed motion and resolution to deny applicant's use permit. Thank you for your consideration.
Thank you for your comments. Do my colleagues have any questions for any of the participants or discuss amongst the board? Or a motion?
Mr. Chairman?
Ms. Malice?
So what I'm looking at is an oversized lot that's conforming in width. And, but the house that's being proposed basically maxes out the footprint and coverage. So it's the biggest house that could be built on this site. To me, I think that's a reach. The fact that the setbacks are as in the original house, I don't really see as relevant to a completely new redesign. So I'm not inclined to support this.
Thank you, Ms. Malice. Ms. McCoskey?
Yeah, so I am in agreement with Ms. Malice, and I think that one of the issues is that when, as she noted, building a brand new house, it's much more difficult to reach the rationale that the proposal will not be in conflict with the purposes of the master plans and land use and zoning policies of the county, because I think it will. And in this case, we don't have, it's not an addition. It's not something that couldn't be built in conformance with the zoning ordinance. And so I would think that finding would be difficult to make, and I have a hard time supporting it because I think you could have something that's almost this big and a very nice house and meet the requirements.
Thank you, Ms. McCoskey. Ms. Freshman?
Yes, I just like to comment that the comments from Mr. Kurtz about I'm very familiar with this neighborhood. And to my knowledge, none of the new homes being built have come before us. And that means that even though they're ginormous and maybe out of character with the neighborhood, it does mean that they were designed without exceptions so that they didn't have to come for an exception to the BZA. And that my point earlier was just that when you start from scratch, essentially, there's a established footprint. And you can build within that footprint, in which case, knock yourself out, you just get your pull your permits and start going. So that's my concern, is that yes, there are a lot of big houses going up in that neighborhood, but since, to my knowledge, none of them have come here for exceptions, that means they have been able to figure out how to build it, however big, within the parameters that are required by the ordinance.
Thank you, Ms. Freshman.
Mr. Chairman, I can make a
Malice.
motion. I move that the Board of Zoning Appeals approve the attached proposed resolution denying use permit B-12059-25-UP-1, subject to the conditions listed. And I would modify the fourth whereas to state that it will be in conflict with the purposes of the master plan. So I would take out the word not.
I'll second that.
A motion for a denial as advertised made by Ms. Malice, seconded by Ms. McCoskey. Is there any further discussion? Hearing none, I will call the roll.
Mr.
Ms.
Jones?
Malice.
I will say one thing. I know the applicants can come up with a design that would basically be right, but to the neighbors, it will be a big house. They have a sizable lot. So even though they're going to be building it, build more narrow, they still have a lot to work with. So it won't be a substantially smaller house.
Thank you, Ms. Malice. Ms. Malice.
Voting aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for denial passes 5-0. Not the result I'm sure you were hoping for, but is the result nonetheless. Thank you, and thanks for everyone's participation as well. Ms. Klein, can you please call do we have 2 withdrawals next?
Yes.
Okay, can you please call those
Yes.
cases?
Case number V-12036-24-APP-1, carryover withdrawn, and appeal request at 1225 North Quincy Street, Ballston, Virginia Square. Staff recommends as follows. The subject appeal request has been withdrawn by the applicant and no further action is required by the BZA.
Thank you, and we have no speakers who wanted to address that matter, right? Correct? Okay, can you call the next?
Case number V-12041-25-APP-1, carryover and withdrawn, an appeal request at 5041 and 5043 25th Street South, Claremont. Staff recommends as follows. The subject appeal request has been withdrawn by the applicant. No further action is required by the BZA.
And again, we have no speakers who want to address that matter, correct? Okay. Can you call the next case, please?
Case number V-12086-25-BA-1, a variance request by Paul Wujay and Carrie Lynn Connolly, the owners, to permit a rear yard setback of 17.5 feet to the main building wall, 17 feet to the eaves, instead of 25 feet to the main building wall, 21 feet to the eaves as required, and to permit an addition that is greater than 50% of the floor area contained in the existing building as of July 15th, 1950, regarding a 2-story rear addition to an existing townhouse dwelling in the RA 8-18 zoning district on the premises known as 1046 North Monroe Street, Ballston, Virginia Square. Staff recommends that the board adopt the attached proposed resolution denying the variance request. 2 alternative resolutions have been provided to the BZA see fit to approve the variance request as advertised or with a 22-foot rear yard setback, and note there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Ms. Klein. Ms. McCoskey.
Is there a rationale for the proposed motion that has a 22-foot setback recommendation?
The rationale is that the 3 properties directly to the north on Monroe Street have all received variances for setbacks. between allowing either a 22-foot or a 23-foot rear setback as opposed to the requested 17.5-foot setback, where 25 feet is required for all of the townhomes on that street.
Thank you.
Do you know what the time frame that those variances were granted?
I can look that up for you and provide that to you.
Thank you. I mean, it might not be an issue. We'll see. Anything further from my colleagues? Would you like to speak to your application?
You would. Thank
Sure,
you.
yeah. We sent a presentation yesterday to display. Yes, this is the one.
That's it. Thank you.
We can go, first of all, yeah, good evening, everybody, and thanks for having us. We can talk about the variance request and our logic behind it, or we can address the staff recommendations and dive into that. So which would be more helpful in our 5-minute?
I mean, that's up to you.
Okay.
One thing I would like to discuss, for the board is the alley behind our home. So as you know from our documentation that we've submitted, we are asking the county to factor in the existing alley between the homes on Monroe and Nelson Street as part of our setback distance. And I just want to jump ahead to slide 4 to provide a little bit of context about the alley. So this is the picture of the alley in question. Keep in mind, this is what the alley looks like on a very good day. There's usually tons of trash back there, dead rats, standing water. We and our neighbors have asked the county on multiple occasions to address these issues in the alley, which is technically county-owned land. In the summer, due to standing water, every house in the neighborhood has a huge mosquito problem just due to the water that's sitting back there. We've seen people using drugs in the alley recently. The alley was also the entry point for a home invasion on our street a few years ago. So since we've moved it in 2016, we've tried to work with the county to clean up the alley. We've asked them to pave it, correct some of the drainage issues. The furthest we have gotten was a gravel dump. This all goes to say that we, based on our experience with the county and their limited involvement with the land back there, we don't foresee the alley being altered or used in the future in any way. So just wanted to provide a bit of context about the alley, which is kind of just dead space that's not really used for anything right now.
Slide before.
Sure.
And we'd like to just talk about the basis for our variance request on the slide before.
Yeah, so we are asking, our first request is that you consider the step back to the property line, a little over 17 feet from the back of our property line versus the 25 feet stated per zoning in RA 818 by including this existing alley, which is 15 feet wide as part of the structure setback distance. This would allow us to build a structure that is 7.5 feet longer. By requesting this additional 7.5 feet, which is exactly half of the alley, we ensure an equitable distribution of space. And this approach maintains the required 50-foot separation between structures while preserving our neighbors' future ability to potentially utilize that space as well.
Slide 6.
Sure. Jumping ahead to slide 6.
Slide 6.
So we have a few supporting statements here, just backing up our request. Our home was built in 1938. It's lot 18 of Monroe Courts. As mentioned previously, this is one of the many houses in Arlington that predates the current zoning designations. The area has undergone significant zoning and infrastructure changes over the years. The original design included this rear alley that's currently unused for utility and trash access. Trash is no longer collected in the alley, and it's very scarcely used for any utilities. As I mentioned, it's technically county land, but it is maintained, as well as it can be by the current residents of our neighborhood, although we have no HOA, so it's very ad hoc and not particularly, well organized. The alley is unique to Monroe Courts, and it's really not typical of the RA 818 zoning. And we feel, there are other homes in the neighborhood as well as in the zone that do not comply with the 25-foot setback, as mentioned by staff.
Okay. Why don't we jump ahead to slide number 9? Our various request was kind of a thoughtful and restrained design choice. Zoning allows us to build a 12-foot rear extension with a maximum height of 40 feet. So at 12 feet and the 619 square feet allowed from the GFA calculation, we could build 4 stories, 154 square feet up, which would be larger than our current living room. We chose not to pursue these additional vertical stories to avoid disrupting established roofline rhythm and scale. And addition is concentrated at the rear, which is least visible to the streetscape. Our lot coverage also remains below the 56% limit at approximately 50.6%. We could have asked for another 4.5 foot of setback and still adhere to the requirement, but the logic behind the alley being 15 feet wide and 7.5 feet additional request is the basis for our variance request. We acquired the property 10 years ago in good faith. Family needs have evolved over time, two small children. We value the neighborhood, have strong positive relationships with our neighbors. We have received positive support for the proposed addition and are not aware of any opposition. We see ourselves as long-term tenants. Many homes in the Monroe Courts are managed by large property management companies, resulting in a high tenant turnover. And the existing floor plans of these homes are often not well suited for families, which is a common challenge for homeowners in similar situations.
And
See, I'm over time, so.
thank you.
Do my colleagues have questions for this applicant? Ms. Mellis?
Either that or for staff. Who owns the alley?
The county.
The county, it's the county property.
Yes, ma'am.
Anything further, my colleagues? And we have no speakers for this?
Correct.
I'll just say that, well, I don't disagree with the applicants that they should be able to build a little further back than what the zoning ordinance allows. I'm not sure that it's our place to overrule the county board on their ordinance that they can't build greater than 50% of the floor area as of July 15th, 1950. And so if I just don't think we should substitute our judgment in for what the county board has as their judgment. And so that is something that is clearly within the county board's purview to change that ordinance, which would apply to all similarly situated properties, which is one of the standards that the state of Virginia gives us when analyzing variance requests, right? So I'm not even getting to the, what the setback is alley versus not alley. My trouble is with, overruling the county's board on that 50% requirement.
And Mr. Kaplan, if I
That's-
may, I provide.
That's fine, yes.
The dates of the variances granted north of the property ranged from 1955 to 1989.
And you're not going to be able to answer this question, but I'm going to ask it anyway. Did previous BZAs grant a variance to the 50% of the floor area requirement?
I
Although
am
should-
not aware of
right.
that component of those variance
That's
requirements.
what I figured. Although, under the variance area, as my colleagues well know, variances don't set precedent for other variances, right? That they're supposed to be one-off unique circumstances. This freshman.
Can I just clarify? I mean, first of all, if this alley is unique to this zoning district, then that's a hardship in and of itself. But is this request in line with the properties to the north that have had extensions? I wasn't clear as to how that.
No, it is not. So the current request is for a 17.5-foot setback, and the properties directly to the north
223.
have a 22 to 23-foot rear setback.
Okay, so they would extend beyond what's approved
Correct.
to the north. Got it.
And there is an alternative resolution provided for us that gives them a 22 feet instead of the 17.6 that they're requesting.
But we would generally want to see the floor plans for that, right? Because if we were to grant a variance at a 22-foot setback, then the applicant could very well build to 4 feet on that, 4 stories on that, when the neighbors and other community members might have something to say about that. So we'd probably want to get additional feedback if these applicants were interested in doing that.
Does that mean a deferral?
Well, I don't know
What are you
that,
suggesting?
I don't know that the applicants are even interested in that, right?
Okay.
But this board, I mean, I can't remember a time where this board has approved an alternative resolution without actually having the plans before us.
We would need to have plans even because all of our approvals are conditioned on a set of plans as part of the,
Which
part of the
suggests a
pack.
deferral.
If the applicant were interested in those alternatives, right?
If we have-
I'm just saying if we can't approve something without reference to a plan, if the plan doesn't yet exist,
Right.
you
so-
have to defer until such time, if they agree to it.
Or there's still the option to deny, simply deny.
Of course.
Would the applicant like to speak to the 50% requirement?
Sure, yeah. In slide number 16 of our presentation, we figured that the GFA 50% may be an issue. So the original variance request number 1 was associated with the logic of splitting the alley in half, adding 7.5 feet. So if we do comply with the 50% GFA cap, that would change the variance request from a 17.5 foot request to a 19.25 foot request. And this is, I'm okay with this. If we remove that variance, we're okay with this. If we remove second variance and get this, it eliminates a couple feet, but it would still meet our family needs, I feel.
So that would be a change, one that would require staff to redo their analysis. So that's not something we could approve tonight because again, we would want to see the actual dimensions and layouts before us.
Okay.
But I'm also sensing that staff would still not have a recommendation of approval based on what's around the neighborhood, as I suspect that that's the reason why that they produced the alternative resolution, although I will not speak for staff, obviously. But if they provided an alternative resolution of 22, 23 feet, I would infer that, or a reasonable inference could be that might have more support.
Which property?
Staff is obviously going to speak for themselves.
Mr. Chairman.
Ms. Malice.
Yeah, simply going to the 50% cutoff and having a 19, possibly a 19.25 setback is not something that, we can guarantee that we would approve.
Especially without plans.
Well,
can't make
under
any
no
guarantees.
circumstances would
Right.
we, but even,
Right.
so even coming back with plans that, reduce to 50%
would-
GFA is not something that you can count on this board approving.
Ms. McCoskey.
Yeah, so this is a variance we're being asked to approve, not a use permit. And I'm concerned that we do not have a hardship that's a result of the size, shape, or other effects of the property. I recognize that there is a hardship in that the ordinance does restrict what can be built here, and it makes it a very small house. But I don't think that is the kind of hardship that would justify a variance. So I have a concern about meeting that standard. And I guess we would have that problem no matter what happens, because a use permit can't be done in the zoning district here.
Right, even the setback requires the variance standard.
Right,
Yes.
because this is not one of the residential districts that's allowed to have a use permit. So, unfortunately, I'm sorry to even raise this because it just makes the problems worse with trying to find something. We're trying to allow something here, but I think there's a problem with the variance standard that we run up against in trying to allow something here.
So the variance is much stricter than a use permit, and the standards are much higher. And in your district, the variance standard must must be met both for the 50% footprint and the setback. Have you thought about the hardship element?
The hardship of
How you know, why you might meet the hardship standards?
yeah, slide 10.
Yeah, yes. So we believe the hardship arises from the pre-zoning layout of Monroe Courts, the lot size.
From the what? I'm sorry.
The pre-zoning layout of our neighborhood of Monroe Courts.
It's slide 10
If we could pull our slides up again. I feel like we have a slide for everything. Thank you so much. I think it's actually up a
Other way, yeah.
bit. Yeah. We have some plans here in case you're interested. Yeah, but it'd be slide 10. I believe this is 20. Perfect. Thank you so much. Okay. So we believe the hardship arises from the pre-zoning layout of Monroe Courts, the lot size and depth. The attached townhouse configuration really does limit flexibility. It's a fairly shallow effective lot depth compared to detached homes, and as well as the rear public alley being part of the original development pattern. It's a very unique area, we feel.
So, Mr. Chairman,
Ms. Malice.
so one of the standards is could this be corrected by an action of the county board? In other words, is it general and reoccurring? And to me, your property is not unique. It's very similar to other properties. And the standard basically says we could only grant a variance if you have a unique problem, not a problem that could be solved with an ordinance change by the county board.
And so I would be interested in hearing more about the hardship, but I don't think we're going to get that information tonight, right? If this is this the only block with the alley issue in the back? Is this house smaller than, the smallest house in the neighborhood, right? Like, there is a possibility of a hardship here, but I don't think that the applicants have established it. Because we don't know if this lot is reoccurring in the RA18 district.
Well,
Is it similar to the ones on the block?
But is it reasonable for the county board to update an ordinance based on one block in this zoning district? Right, when we dealt with this issue with the R27 a year ago,
We
right,
established hundreds of.
right, hundreds and hundreds of that, and we had dozens of them come before us. But I just don't think we have that analysis done to be able to determine if there's a hardship that this board can act on. As Ms. Freshman had alluded to that at the beginning.
Yeah, I come back to the alley as an issue. I think it does create an issue. And if it's, but without more research, I guess we don't know if in fact it's unique to this block compared to others in this with the same zoning. But I do think it creates a constraint that might not be there if the property lines were 7.5 feet deeper on both sides.
And
Are they the standard depth? Are they a conforming depth?
it is conforming.
Yeah, it's a conforming depth.
The subject property is located within the boundaries. I just read this a second ago. It does not contain a minimum average width, so there might not be a depth.
There's no depth requirement for individual townhome lots. The depth is measured for the entire townhome building
Okay.
itself, or width, I should say. I'm sorry. The depth of the property is 85 feet.
I could get there on hardship, but I'm not sure I can get there on reoccurring. At least on the record before us. Right, there is, to me, there is an inherent hardship in that the ordinance allows for an addition that is greater than 50%, but this applicant can barely do an addition if being held to the 25-foot rear setback. That seems to be somewhat of a hardship to me, at least. But reoccurring is difficult.
Yeah, I mean, I think that there's a good amount of thinking to be done on this. I'm not with you on that being a hardship, because I think the hardship needs to be based on the size and shape, and I guess maybe location of the property could be argued, but again, I have a hard time when we look just at, you know, this map with the townhouses. I have a hard time saying that it's not shared generally such that an ordinance change could fix the problem, because frankly, I mean, the ordinance specifies that you go from the property line of the right of way, and that's the alley line is how you measure it.
But-
So I wouldn't have a problem deferring this and trying to look at it more with the applicant, or maybe, although maybe on today's thing, we ought to, I mean, I'd be prepared to make a motion to deny if that's what everybody would agree, or if there's a sentiment to do that. And I think it is a case that could be looked into further, but I do think it's probably a case that would require some kind of county board action to change zoning or do something different to allow this issue to be fixed.
I just wanted to point out that I was resting my hat on hardship on the improvements thereon, which existed upon the effective date of the zoning ordinance when this house was built in 1938, before the enactment of the zoning ordinance. So that I think we can hit the hardship based on the actual physical condition of the property under that one.
Okay.
But that's neither here nor there, because I think we're all struggling with the reoccurring, if not other things.
Yeah.
How
Miss-
might the proposal be altered to make the issues go away? I guess it's a rhetorical question, but
Right.
I'm looking at trying to work to see if there's a solution so that they can come back with a plan that can meet I understand the hardship issue.
Right.
But I'm just saying, at the moment, we're stuck. And I think that, I'm sympathetic to the application, so I would like to see some version of this work out. And I don't know if staff has suggestions, or, Stephen Guru or whoever, or if it's just not possible.
So my brief calculation here, right, they're asking for a 15-foot addition, which leaves them at a 17.5-foot setback. And so by right, they would be able to do 15 minus rounding to 8, right? So they can do a 7-foot addition by right. So if I don't know that this board is willing to do that, but so the answer would be somewhere between 7 and 15 feet addition.
Mr. Chairman.
Was that math correct? No. Okay. I bungled that.
We are in the right, my researcher, whatever, we are in the right to build a 12-foot addition out the back and 40 feet up.
Can you go back to the previous slide? Right. So that proposed addition, what's the depth of that proposed addition?
19, I think it's 19.5.
Oh, okay. So I picked up 15.
So yeah, 12 plus 7.5 is 19.5.
Mr. Chairman,
Ms. Malish?
I'd like to move this matter along, and I'm going to make a motion to deny. And if that doesn't pass, then somebody can take the next steps. I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-12086-25-VA-1, subject to the condition, well, it's a denial, so it's just as per the denial resolution.
Thank you, Ms. Malish. Is there a second?
I'll second.
A motion for denial made by Ms. Malice, seconded by Ms. McCoskey. Is there any further discussion? I'll just say I will not support this motion, although I will not support an approval either. I would support a deferral, but at the moment, I'm not at a denial.
That's where I am as well.
Thank you, Mr. Kumana. So I will call the roll. Ms. Malice,
Yeah, aye.
Ms. Freshman,
No.
Ms. McCoskey,
Aye.
Mr. Kumana.
No.
Chair votes no. Motion for denial fails 3-2. So the question, I guess, for the applicant and I guess less so the BZA is there anything, and the board's not going to answer this tonight, but so the rhetorical question is there anything that this board would approve short of what has been advertised here tonight? And so would a deferral help you go back to the drawing board to try and come up with, after having heard the discussions tonight?
I suppose the deferral would allow us to come up with new plans. Removing the second variance request of the 50% GFA, adhering to that, submit new plans showing compliance with the 50% GFA, and continuing to hammer on the hardship portion. That sounds like.
I mean, without,
Concurrence?
I think that no one on this board is going to be able to give any, guarantee of something that would pass. And we're all struggling with what is reoccurring, right? At a minimum, reoccurring. And I know some of us have struggling with the hardship as well, right? So I think that, like, you've heard the discussion. You have read the alternative resolution, right? Where if this board would approve anything, I don't know, right? I mean, I think we're split, as we have been split on a lot of these similar decisions in the last couple of years as the R27 cases have come before this board. I'll also add that, like, go to the county board, complain that you are not able to get the same deference as other similarly situated homeowners in both townhouses in R27 and in single family homes. So that being said, we're looking at a 2 or 3 month deferral, because if you're making your plans, you're going to have to go back and work with county staff and outreach. I'll also add, I think you had a lot of trouble with your outreach with with neighbors. There's a lot of non-responses.
Yes.
I think for something like this board is going to really want to see, that those surrounding neighbors and how they feel about this, because we don't want to create problems for you and your neighbors in the future.
Including in the rear.
The bar is just very high for variance. Even if I personally agree that the housing stock in this county is not suitable for families, it's not. I mean, it is a hardship in my opinion, and just generally speaking. But it's just, if it was a use permit, it's a different discussion. Generally speaking, I'm sure as you sat and listened today, it's different. And that in itself makes things even more difficult for you. So, I'm very sympathetic to, like, what you guys are trying to do.
Yeah.
Okay, so opinion on 2 or 3 months?
Okay. Thank you.
So why don't we do 3?
We can do it in 2 if.
2?
Staff suggests that 3 is a more
3.
Reasonable time frame for everyone you'll need time to resubmit. We're already looking at March applications.
So January. So we're looking at April for a 3 month deferral. And just to be clear, I don't want to give any, like, false hope that this board will approve anything with a deferral. I think we're just trying to get more information and give an opportunity to have more information and a different plan put before us. Right? So I don't want to give any false hope there. Right? As you see, we're a split board on these issues, as we have been for years. Would someone like to make a motion for the April?
I will. On case V-12086-25-VA1, I move deferral to the April 15, 2026 BZA meeting.
I will second that. A motion by Ms. Freshman for a deferral for April 15th, seconded by myself. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
No.
Ms. Freshman,
Aye.
Ms. McCoskey,
No.
Mr. Kumana.
Aye.
Chair votes aye. Motion for a deferral passes 3-2.
All right, thank you.
Ms. Klein, can you please call the last case?
Yes. Case number V-12087-25-UP-1, a use permit request by Per and Erica Midbow, the owners, to permit a rear setback of 2.5 feet to the eve instead of 10 feet to the eve as required, to permit a side setback of 1.1 feet to the areaway instead of 5 feet to the areaway as required, to permit a street setback of 23.3 feet to the building wall instead of 25 feet to the building wall as required along 6th Street South, and to permit a street setback of 18 feet to the porch column, 17.3 feet to the porch eave instead of 21 feet to the porch column, 19.5 feet to the porch eave as required along 6th Street South, regarding a one-story detached accessory building with basement and porch on a corner lot in the R6 zoning district on the premises known as 601 South Taylor Street, Barcroft. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised. Note, there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Ms. Klein. Do my colleagues have questions for staff? The applicant is with us, clearly. Would you like to speak to your application?
Please, thank you so much. And I had thank you so much. All right, fantastic. So my name is Per Midbow. I'm going to be speaking to you today about my use permit request for 601 South Taylor Street. This overview picture is a picture from the timber framer that we're looking at. This is a much larger structure than I'm asking for, but to give you a sense of the kind of structure we're looking at. I'm going to speak to you first about sort of my design goals before we jump into the rest of the presentation about the property. But for the last 20 years or so, I've been a very avid woodworker. I've been working out of a basement shop very closely with my father. I lost him unexpectedly last year, and because of that, I have pretty much had to stop woodworking, and because I can't move things in and out of the basement anymore. And so we're looking to build a building that is close to the road, that's accessible, that I can use at a single story, and include a bunch of safety and single person woodworking technologies into. While designing that space, I was very interested in maximizing the green space and the safety for my children. They use our yard, and so to the degree that we're building something new, I want to be able to maximize it. That's the primary goal for the rear setback, which is my primary concern here. And then, of course, to respect my neighbors, neighborhood scale, neighborhood style. I have been a lifelong Arlington resident. I grew up in this neighborhood. Been living in this, this house for the last 20 years or 18 years or so. And so, well, the adjacent property, but the goal is really to get to that. And so we've had a lot of neighborhood outreach. We've talked to pretty much, most of the folks on the block. And tried to really integrate any comments that we got back into the design. Next slide, please. So the vision for this, you can see in the upper left-hand corner, is something that is designed to fit in the Barcroft neighborhood. It's a lot of brick and white molding, and looks as though it was designed. The goal is to look as though it was designed with the property in 1947. I need it to be bright, accessible, and open. Again, I'm having to work largely by myself. And I want to be able to integrate dust collection and these safety systems like a winch to be able to move things around by myself within the space into this, and take particularly the dust collection outside of my house and away from my kids and the respiratory health of others in the house. And then noise control has been an enormous part of our design process, in part because I like to work in a quiet shop, but also because it's very important to me not to be disturbing our neighbors with any of this. And so one of the pieces we're looking at is a basement element. And so we would put particularly the noisy dust collector in the basement so that it would be blocked from a noise by two separate walls before it would exit the structure. Next slide, please. So I'm going to orient us. This is the current backyard as it stands. The far right of that picture is the house. And the structure we're looking to replace is that right in the center there. That shed or its predecessor has stood in that spot since the house was built in 1947. And what our plan is to push towards the house and out towards the road where this picture is taken from. And I just wanted to highlight one thing in this picture as well. You can see along the rear property line that there are a lot of bushes. Those sight lines will not change as we push towards the road, because as we replace that with a wall, as we move forward, they'll still have limited, those sight lines will be obstructed as they currently are. Next slide, please. So this is essentially an overview of what we're asking for. As you can see, the primary relief that we're requesting is that rear setback. We're also hoping to put the stairwell to the basement on the back side to keep folks, as they're moving in and out of that backyard space, from risking falling down, because it's a pathway to the street. And so we would like to put it there. We also own the adjacent property number 50, or it's 605. It's shown 53 here. And it would allow us to access from both properties, and it puts it on our property where we'd be the ones most affected by that variance. The last part of this is that there is a front porch element to it that we would like to align with the one-story addition that you see there for visual continuity between the property, and make it just look nicer from the street. And that requires us to have a little bit of a variance right on the corners there, as you see. Next slide, please. So this is a summary of what our requests are. Again, the primary one is the 2.5-foot setback, as well as the goals we're trying to achieve. And recognizing I have 14 seconds, I'm going to just note that the next 3 slides are examples of similarly situated corner lot properties in R6 in Barcroft or the surrounding neighborhoods with similar structures. Thank you. I look forward to your questions.
Thank you. Can you scroll up one page? What the 2 red lines on the bottom? What are the 2 lines?
The 2 lines, one is for the setback, of which I believe is 18 feet from the
porch.
For the porch, correct. And then the one above it is for 25 foot from the road. And there's again, it clips the corner of the structure right there.
And this may have been in the staff report, but does an accessory dwelling porch qualify for the extra setback relief for a porch?
It is a porch, so
Okay.
yes.
Learned something new tonight. Okay. Sorry. Do my colleagues have questions for this applicant? None. Ms. McCoskey, please.
Yeah, it takes me a minute to formulate, but can we put that picture back up just so, I guess, so right now you do have those 2 red lines that you just talked about.
Yes, ma'am.
They show that you couldn't move your proposed building closer to the street at the bottom.
Correct.
Because you'd need more relief. And what did you say about, you own the property next door, that lot 53?
Yes, ma'am.
Okay. But is there a house? There's a house on that. Is there a house on that do you rent that out or?
No, that's actually the primary residence there.
Okay. So so explain to me, you own 2 lots?
Yes, ma'am.
Point out to me, just tell me where the 2 lots are. I'm having trouble.
At the top of it, 53 is where I sleep at night. And then the lot we're talking about, we had purchased for family.
Okay.
Unfortunately, again.
Okay, so, but there is a house on lot that's labeled as 53, and there's also a house on 54.
Yes, ma'am.
Okay, and you all live in the house on 53. Does anybody live in the house on 54?
There is folks living in there.
Okay. I have a question. When you got the initial sort of sign-offs from your neighbor, you submitted your application with like 24 expressions of support. Had those people seen the size of what you planned to build at that time before they
we had the conversations with them and I didn't show them this because I drafted it but they knew the sizes that we're looking at.
Okay. Because I thought someone, and maybe it's in the newest supplemental materials, said we didn't know it would be so big.
I haven't seen any supplemental materials.
Okay.
There was supplemental materials that were uploaded to the agenda packet this morning of a public comment submitted last night, which indicated we can pull that up if you would
Okay,
like.
those were the
That's great.
online comments that somebody submitted to zoning. Okay,
Correct.
all right.
They were primarily concerns about noise and traffic and that sort of thing that we might normally be conditioned.
So there, in our supplemental material, there's an adjacent neighbor that's opposing the project. Are you aware of that?
So we had received, and it's in the materials I submitted to you, comments from them and had provided comments back. But this is actually the first time learning that those comments were not sufficient.
I think the supplemental material is dated the 13th. No, it's dated
on the
January 13th.
Would you like
So-
me to provide context regarding the date of that letter? Staff received, that letter was written on the 13th. It was mailed to, I believe it was dropped in to county staff late last week.
Okay, yeah, there's no other dates. 120, no, I don't see any other dates. I'm looking at your supplemental.
Yes, I'm happy to answer any date questions.
Okay. So just be aware that apparently there's still a remaining concern from your adjacent neighbor. I think this is a very large project that you're proposing, and I'm not sure how this exactly fits in with this neighborhood. I guess, what is the, you have an oversized lot
Mhm.
and it's conforming, and yet you're not able to figure out a design that is compatible with what you're looking for.
So the concern that we have is essentially twofold. The house that exists right now is a little bit further back than the rest of the houses on the street. And so it's further back in a lot, kind of limiting the backyard area. And then it is also narrowing towards the back, which gives us a situation where, I need a certain width for a lot of the woodworking processes that occur. So in feed and out feed of the machinery. And so, it's not machinery, it's a table saw, but I need that space. And so placing this, any closer to the house would end up, not really giving me the width that I'm looking at as far as I can tell, and allow me to also have the stairwell in a way that doesn't involve creating basically a catchment area for folks as they're moving in and out between the backyard space.
What's the?
Sorry, Ms. Mouse, can I just ask staff to bring up that diagram again? So while you're having this
Right.
discussion, we can all look at it.
What's the
The
dimension?
applicant from this slide. Sorry,
No, I understand.
the one with the two red lines in the PowerPoint.
In the applicant's presentation. Or what is the dimension of the back lot line?
Is that 54 feet, it looks like?
Is that 54 feet there?
I believe
Yeah.
so.
So that's 6 feet different than the conforming standard that is in the back. Have you considered modifications to your home, your house there, in order to free up some space?
As in tearing something down?
Mhm.
I have not.
Because, you know, you're putting a lot on, you're putting a lot on the lot and
I think we're still well below our coverage limits.
yes. I'm trying to help you think of a way that this could be more compatible.
Could I ask staff a question? Is this building to be built being treated as an accessory structure to the house on this lot?
Correct.
But it's not being used by whoever resides on that lot because they reside on the next lot. So I'm just wondering if, as a matter of use, it can be an accessory structure because it's not incidental to the use that's the house on this lot, the single-family house or brick dwelling. And I take it where it says two-story addition and one-story addition. Those are addition. This is not something that will be built in the future.
No, ma'am, this is,
That's already there.
that's existing,
So,
correct.
so I guess my concern is an accessory structure, the use is supposed to be incidental to the main use of the property, but it's not going to be used by the people who are residing in that dwelling unit. Is that correct?
I mean, we own both properties. The people who are currently living there would not be using that part of it. But yeah, I mean, that is accurate. In the future, that may change.
Okay, right, okay.
Can I ask a question? Did you consider putting this on the property that you live in?
I did. Unfortunately, getting to and from the road creates quite a bit of additional movement. And so in terms of accessing the street, this gave me the best opportunity to move materials in and out again safely, and that's by myself.
I guess we're struggling with trying to find a solution that might be workable here because we may not find this particular design workable.
Okay.
So, and I just to try to get the thoughts developed further. So as far as the setback from the property line that's between your two properties, that's a very small relief that's required. And it's also pretty small relief where the two red lines are just barely encroaching. And I think you actually said this, and we're completely upfront with this, that the biggest issue is the setback from the rear property line.
Yes, ma'am.
And the problem is that it is it should be, what,
10 feet.
10 feet. Okay.
So what's the feasibility of shifting the whole structure over feet, right? It's 1.1 feet. I'm sorry, wrong measurement. It's 2.5 now. So if you shift it over somewhere between 5 and 7.5 feet, then a lot of your problems seem to go away.
They do, and we would.
To me, it's like a lot of the reason that you're here before us today is a design issue. It's a placement issue, right? You want a front porch, you want stairs on the inside, and you want to be 2.5 feet from the property line, right? Those are all choices to be made.
Mm-hmm.
And so a lot of this can be done by right with different choices. And I think that's what we're all struggling with, that this is a giant accessory structure, not with a great purpose, right? I do woodworking in my garage, so I appreciate that. But I think the neighbor or neighbors have valid concerns.
Okay.
Being so close. And so it's a little bit more than it's defined as a one story, but it's definitely a little bit, in my view, it's a little bit big. It's a big one story, right?
Okay.
And I think that's what we're all struggling with, is that there are there are other design choices that can be made to alleviate some of the setback relief being requested, in which staff has not found any comparables for us to make the findings that we need to make under the zoning ordinance.
Okay.
Can we go, I think we never scrolled
I was
down
just about to say that too.
to the pictures that were,
Yeah,
showing
we didn't
similar
allow the
things.
applicant to show
Okay.
us compatibility.
okay,
Yeah.
so
So
there they are.
So in terms of compatibility, these are the structures in my neighborhood, including the top left, which is on my block and just the next corner over. All of these are corner lots and have structures that are very close to the property lines. All of these are within Barcroft. The next down is within Ashton Heights. Do you mind scrolling to the next one?
These are garages, right?
I don't know what use they're being put to. I assume they're garages. I mean, mine would also have large doors on the front of it.
Because I think the standard for a garage is different than an accessory building.
Ms. Klein,
I can confirm that momentarily. Let
I
me
think-
review that.
Yeah,
can you confirm that is there a difference for us for zoning placement on an accessory structure versus garage?
There's not a difference.
no, because a
It is.
garage is an extra accessory structure, but I think what there are differences as we've looked at with other accessory structures in terms of floor area, total floor area, or number of stories
Right.
of any accessory structure. Can you go back up to the,
That doesn't mean that we still have to make a compatibility
right,
determination. And so that's up to us to determine whether the applicant structure is compatible to other like garages in the neighborhood. I think that's fair game for us to decide.
And yeah, fair enough. And then the last one also has sets from Glen Carlin and do you mind going down to the last one? I apologize. From Glen Carlin and Douglas Park. Or apologies for the typo there, from Douglas Park. And some of these are larger structures, including that one there that's on First Street South.
but we also don't have any information on
The circumstance.
what their setbacks are.
Or distance to property, right?
Yeah.
I selected ones that were close
Right.
to the back of, I
Right.
mean, they are certainly
right.
within 10 feet. I don't have.
And this is all information that could be provided if we choose.
And the question is whether these are really comparable since they're at a distance from.
Right. We don't know the distance, but that is all information that could be determined at some point.
Well, staff did research, the normal research for compatibility, which is in a much closer area.
It is, yeah, a smaller radius. Yeah.
Right.
So again, the question is how do we move this forward? Because, if you move the structure towards the house, you definitely can eliminate the back setback request. And I think you can I think you're within the street setback because I think I know you no longer have a street setback problem.
Yeah,
Yeah.
we can probably, and frankly, I'm willing to forgo the porch if that's necessary too, but the biggest concern we have is that rear setback, because as we move it closer to the house, then it feels more congested, unlike what I would think of as an R6 space. And so, we didn't want to create basically a narrow alleyway there. To the degree that we could meet somewhere in the middle, I think that we could come through that.
I mean,
It's kind of a catch-22 with the zoning ordinance, right? Because the applicant does have a point that the closer it gets to the house, the more congested it looks. But on the other hand, that's not what the zoning ordinance allows.
right. I mean, these are
I mean, that is what the zoning ordinance allows.
these are
right?
preferences.
These are
right?
preferences, right?
Yeah, and I would say
Right.
that when we have a corner lot, where we have our open space is on the street frontages. And so the fact that it is a little more congested in the back,
Right.
but that's where the zoning ordinance kind of directs you to put your structures. And so to me, yes, it's a little more congested. There seems to be a lot going on this lot, but that location of it, as I think about a corner lot, is the right location for your structures.
In fact, I am on a corner lot that looks not dissimilar to this, and I have a giant garage attached to the house, right, you know, right where the your patio is, right? And so, you know, I'm intimately familiar with that.
Yeah, I think we have to balance, you know, preferences with, you know, the standards, the
right.
standards that we've been given. I guess question for staff, how close can you go to the building, to the house structure?
8 feet.
8 feet.
And what are we now? What is this proposal? Do we know?
I think
Because I know you've memorized the plans.
I think it's closer to 12. Yeah, or 21. Oh, it's 21 feet.
Oh,
Right.
yeah, you have a lot of room.
So
There's the window well, but yeah.
So like that's kind of our struggle is like, I know it's not your first choice,
Sure.
but that's what the zoning ordinance prefers. And I, you know, you heard, you were here for my previous spiel where, you know, it's not our role is not to overrule the county board's judgment. We're trying to find compatibility with the county board's judgment.
Sure.
Because we are really limited by what their zoning ordinances are. And I am struggling to find compatibility. I think you did, I would want more information on the compatibility items you gave us, but a lot of those were not the same size and girth of that house,
Yeah.
of that accessory dwelling, right?
Yeah, that is, there, I acknowledge there was a variety of sizes. I didn't put one up because it was already in the staff report. There is one at it's a 2-car garage
Right.
that is very wide and very close to the street, on 8th Street that is, I mean, you talked about it in the report, which I appreciated. It is an odd sized lot, but it's a narrowing lot towards the back as is mine. And so, you know, at least within sight of the property, there are at least sort of 2 in that configuration, but I understand what you're saying. We can certainly approach redesign. I just was hoping to get a little bit of clarity on whether there was any potential for keeping a space between the houses to keep kind of light and air and space for folks to play. The rest of the other pieces we can adjust to a degree to meet your needs.
Mr. Chairman,
Mrs.
can I
Freshman,
ask a question? I generally don't object, although I think it's too big. But is there a reason why you have to have the porch, which just adds to the mass,
No, ma'am, we can take that away.
which gets rid of the street setback issues? That, to me, that would help.
So if you were to move it so that you're compliant with the rear setback, you would need to come back still for the setback, the side setback. Is that right?
Correct, yes.
Okay, but you would not need a street setback? And that would
I'm not
I mean,
positive.
the street setback's pretty minimal, right?
be, and if the more further he moves it, the more.
It would be even more minimal, right?
Right.
So
More.
so I
think
understand
it
Ms.
would
Freshman's
eliminate-
point, but
If you don't have a porch, it's
If you don't have a porch too, but.
right,
you
but if
could
we're
even-
sliding it over 5 feet,
you can
then
keep-
you're going to be,
You slide it over 10 feet, you don't need the port, you don't need a.
right.
Be there either. It's unusually large, I think.
For asking for relief.
Yeah.
Okay.
So I guess the course would be since you may need to come back for some relief, that we would defer this matter and give you a few months to consider another design.
I mean, I can have it redesigned for next month or the following month. if it's possible.
there's not enough
is-
time for review and advertisement.
Okay.
And then I think we would ask you to engage with your neighbor
Sure.
who objects
course,
and,
yeah.
and try and get, you know, they may never agree, but it's worth having that conversation of, you know, working out a compromise of
Yeah.
you're going to try and move it and do whatever. I would also have you work with staff and because they have the ability to review some of your comparables and see if they have it. They might not have plats. for any of that as well.
Yeah.
But then they can also kind of walk you through their comps and what the current setback relief for comparable structures are.
Yeah.
And then we still have to address Ms. McCoskry's concern with the accessory structure being on a different property.
Yeah.
I don't know if
And-
that's within our purview or not.
Yeah, I think it's probably not within our purview, but it's an issue, I think, that's going to have to be addressed by the zoning office at some point. So,
Okay, may I ask a question about that? Just
Mhm.
because I don't know if I fully understand. So if that is an issue, are you saying that there is no ability to grant a use permit?
I don't think it affects the use permit
Okay,
approval. I mean, I think that could come back to us probably, but I think there is a question that zoning needs to consider as to whether the use you plan to make of that structure is an accessory use on that lot. And that is, but I can't, that occurs to me and but I don't really have the ability to sort of make that determination of whether that's okay or not. That's something separate that the zoning office would have to talk to you about.
Is the concern that the current tenant isn't the user? Because they could, I mean, in a similar situation, they could rent it out to some local woodworker and the woodworker wouldn't be a tenant either. I mean, to me, that doesn't, it's an accessory to the dwelling. And who's using it?
Yeah.
To me is incidental.
It may be that that's correct. I may be off base, but it just struck me that that's a concern because the use of an accessory structure is supposed to be, incidental and subordinate to the main use of the property.
Well, that
And it may
definitely,
be
that
that-
definitely needs to be settled because otherwise the whole project is. moot.
Right. And it may well be that the zoning office would say it is because that's a workshop that would go with a house irrespective of who is
Currently
working
using
in the
it.
workshop.
Right.
That may be the zoning determination. So I don't think it's something that we need to address, but and that would be something that the zoning office could probably determine and help you with immediately.
okay, fantastic. That's very helpful. Thank you.
I don't like to make promises that they'll do
No,
it
no.
immediately, but I think it would be
we-
fairly short order.
Like
Okay.
to do the other one. Is your opinion still April?
Yeah.
Like it was?
But it's really at the decision of the BZA.
Sounds like the applicant can quickly turn around plans if he can submit them to you in the next week.
Yes, ma'am.
Oh,
Can you-
yes, absolutely. For March.
Review them for March.
Sure.
I move in case number V-12087-25-UP-1 that we defer this matter to the March BZA hearing.
Second.
A motion by Ms. Malice, seconded by Ms. Freshman for a deferral to the March BZA hearing. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskry.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for a deferral to March passes 5-0. We will see you in March.
Thank you so much. I appreciate your time.
Thank you. Anyone have any further business?
Minutes?
Minutes, we do have minutes.
I move approval of the December 18, 2025 BZA minutes.
Second.
A motion for the approval of minutes made by Ms. Freshman, seconded by Ms. Malice. Is there any further discussion on the minutes? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskry.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for minutes passes 5-0. The agenda having been completed as Ms. Freshman runs out the door, this hearing is adjourned.
Who says that? Bye-bye.